Now, they risked their lives for this country in Afghanistan and Iraq, but as this programme has previously revealed, soldiers from former British colonies are being refused citizenship when they leave the army because of minor disciplinary offences. Now, Channel 4 News has learned that commanding officers were unaware when they disciplined staff that their decisions could lead to soldiers being deported. Carl Dinnan has this exclusive report.
Military life is unlike civilian life in so many ways,
Door ahead, door left.
up to and including the military system of justice, where a commanding officer can impose a sentence on a soldier, which it has now emerged can be treated as a criminal record.
It's devastating knowing that, your employer can give you a criminal conviction.
In the summer, we reported on the case of Ismail Baleh Balawai. Baleh spent 13 years in the army, serving in Iraq and Afghanistan. Before he left, his commanding officer had found him guilty at a summary hearing of fighting with another soldier. Baleh, who has a British family, thought this was just a disciplinary matter, until he applied for British citizenship. Then he learned the Borders Agency regarded the offence as a criminal conviction, which barred him from becoming a citizen. A former head of the army told us what he thought of the plight of foreign and Commonwealth soldiers like Baleh.
It seems very harsh to deny a soldier who has given that service to this country, to deny him the opportunity of settling here if that's what he wishes.
The very next day, an internal Ministry of Defence document on discipline policy was circulated. Channel 4 News has obtained a copy of this document. It warns military staff that they may not appreciate the full implications of a disciplinary record. The document on discipline policy says,
effect of a guilty finding at court-martial or summary hearing. A recent case has highlighted the fact that unit staff are not aware of the implications of a finding of guilty for certain military offences. Soldiers may have been wrongly advised of the implications of a finding of guilty by unit staff who were unaware of the facts and had failed to check what they believed to be the case.
The document goes on to say that even non-criminal military offences are entered as convictions on the Police National Database, where they can be accessed by interested parties such as, for example, the Borders Agency. Now, the point about advice is this. In a great many cases, when a soldier is accused of an offence, they can choose between a full court-martial with legal representation or a summary hearing, a lower key hearing where there's no legal representation and where conviction rates are thought to be much higher.
A summary hearing is to deal with minor disciplinary offences. For example, somebody being late for a parade, somebody being not correctly turned out, something of that sort, relatively minor disciplinary offences, maybe in some cases fighting. And the way that a summary hearing works in reality is that it's quite similar to a magistrate's court. A commanding officer will preside over the hearing, he will be the judge and jury, he will decide on guilt and innocence, and he will give a sentence.
Baleh now feels that he may have been wrongly advised that a summary hearing in front of his CEO was a better option for him than a court-martial.
The main reason I chose the summary hearing because I was advised that if I go court-martial, it would impact on my career, as I will have a military offence to my name, and that will affect me getting promoted.
But what happened to Baleh and is happening to other foreign and Commonwealth soldiers is more serious than that. Without lawyers present, they are being found guilty of offences which, although sometimes minor, can still bar them from living in the country for which they have fought. And lawyers have identified further problems with the summary hearing system.
Well, it isn't satisfactory in the sense that the way the conviction is achieved does not comply with the European Human Rights Convention or any real system of justice. It's not a fair system. The commanding officer, in acting as the judge, also acts as the prosecutor, and that creates an irreconcilable conflict.
Baleh has now been allowed to stay in the UK while his disciplinary case is heard again, this time at a court-martial. The Home Office say they are thinking again about the way military law affects immigration decisions.
Well, in response to our report, the Ministry of Defence said the Army issued guidance last year on its website to notify personnel of the potential implications to citizenship applications as soon as they became aware of changes made by the UK Border Agency. This was followed up with a notification in the summer of this year to remind personnel of the changes. The MOD continues to be in discussion with the Home Office about how non-criminal offences in the military should be treated.